There are several terms used for this international law, namely the law of nations, interstate law, public international law, and common law of mankind. Basically, international law can be defined as the body of legal rules, norms, and standards that apply between sovereign states and other entities that are legally recognized as international actors. So, what are the subjects of international law? Basically, there are four subjects of international law in general. The first one is state. The state is the main subject of international law. In the context of international law, the country in question is a country that is sovereign and has its own government. The second one is international organization. International organizations are tasked with participating in resolving violations of international law. The third is individuals. There are some cases where it is possible for individuals to bring case internationally to the International Court of Arbitration. And the last one is public and private corporation. A multinational corporation owns and controls other corporate entities in at least one country aside from the place of incorporation. Therefore, a multinational corporation is established in more than one nation.
Okay, so I will tell about the weaknesses of international law. The first one is lack of legislature. In accordance with their evolving requirements, there's no law-making body in the international legal system can pass laws that apply to the entire international community. The international legislature or parliament is neither comparable to nor interchangeable with the General Assembly. It has no legislative power and its decisions do not bind the states. And the second one is lack of effective machinery. Furthermore, there are no reliable means of enforcing international law. The domestic judicial system is less effective than the international one, since the government is supported by sovereign political powers like the army and police force in the national legal system. Enforcement is likewise supported by these same political forces. In accordance with the federal constitution, the government is empowered to enact and enforce laws. And the last one is lack of political will. Willpower, especially political will, is the hidden ingredient in a person's commitment to a cause that makes things happen and makes them function. Without it, there is either stagnation or at least inaction.
Today, we're gonna talk about the structure in international law aspect in international law enforcement. Peaceful means of enforcement. Peaceful enforcement refers to use the military assets to enforce a peace against the will of the parties to a conflict when, for instance, a ceasefire has failed. Peace enforcement often exceeds the capacity of peacekeeping forces in a task better executed by more heavily armed forces. Peaceful resolution of international claim dispute is a fundamental principle of United Nations law. One of the United Nations goals is to use peaceful means in accordance with the principle of justice and international law, to adjust or settle international dispute or situation that could lead to a breach of the peace, as stated in Article 1 of the United Nations Charter.